You have to keep your audience in mind. And our audience of judges and law clerks, they are editing. They value editing. Another benefit that I would like to uplift with respect to editing is that it mitigates perfectionism. Set aside time for editing. Like any important work, like any meaningful work, editing will take time. And the biggest barrier to successful editing is just not allocating time for it. So the first step in a self-edit is to step away. Take a break from it.
Welcome and thank you for joining us for another Justia webinar. My name is Nina and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speaker for today, Keisha Stokes-Huff. Keisha Stokes-Huff is the Southern Poverty Law Center's Deputy Director of Legal Management, where she assists with overseeing the operation of the SPLC's legal department and coordinates programming for attorneys and law students. Her experience includes a range of legal and advocacy work seeking economic justice, as well as habeas litigation on behalf of indigent petitioners. Keisha received a bachelor's degree from Jackson State University and a law degree from Harvard Law School, where she was a member of the Harvard Legal Aid Bureau. The webinar presentation that you're about to watch will be approximately 1 hour, and Keisha will be taking questions from the audience towards the end of the presentation. So if you have questions that you'd like to submit, you can do so at any time by clicking the Q&A button in the control panel at the bottom of your screen and sending them in there. Now, without further ado, here is Keisha to discuss From Draft to Masterpiece, Editing for Excellence.
Thank you so much, Nina. And I'm very happy to be with you all today. So today we'll be talking about editing. That's a topic that's not specifically taught in law school. Usually, you have a legal writing course that focuses on writing, but editing is something that, for many lawyers, we tend to develop a skill set around during our practice. So I hope that this training offers some practical solutions for you as you consider editing for yourself, and then also how to establish a consistent editing practice for your firm. So Nina introduced me very well. So I wanted to say here that you can reach me on LinkedIn. My LinkedIn information is there. If there's anything during this discussion that you have follow-up questions about that we're not able to address during the meeting, or something comes up for you later and you think about, oh, I wish I had asked this, you can always reach me on LinkedIn. I support lawyers and firms and legal professionals with legal writing and editing and practice management. So definitely feel free to reach out to me there. So we're going to start our session today with a little poll, and Nina is going to send it out to you. And the poll question is, how often are you editing? I regularly edit my own writing. I regularly edit my and others' writing, or I do not regularly edit. So this will help me to get a sense of who's in the room, and I'll try to tailor some of our discussion to the experience level of our attendees. Thank you. So we're about even on I regularly edit my own writing, that's 44%. I regularly edit my and others' writing, that's 41%. And then we have 15% who do not regularly edit. So I think we have information in the presentation that's going to be helpful for all of us. And I'll definitely try to point out some things that I think will be helpful. So our agenda for today, first we're going to talk about why editing matters. We're also going to discuss preparation before editing, some self-editing techniques. So when you're editing your own work, some techniques to do that well and effectively. Also, we'll talk about guidance for additional review. So that's that secondary or tertiary review by other legal professionals of your work. We're going to discuss some technology tools, and I'll have recommendations for you for tools that can assist you with editing and how to onboard those tools into your practice. And lastly, as Nina mentioned, we're going to have Q&A. So definitely, if you have questions as we go along, please place them in the Q&A tool, and then we'll discuss those at the end. So first, why editing matters? Why does it matter? If it's not something that for most of us is specifically taught in law school for how to do, then why does it matter? And the first reason why it matters that I offer to you is that the courts are editing. Prior to my experience as an attorney, I was a law clerk for 3 years, one for a United States district judge, and then 2 years for a United States circuit judge. So I'm going to share a little bit about my experience as a law clerk and how that shapes the court's expectations for what we should be doing as counsel. So I want to give an example for you. So this comes from our basic appellate practice in the United States. Typically for an appeal, the standard appeal is a 3-judge panel. Each judge has about 4 or 5 law clerks at the federal level. And so when the judges are reviewing cases and they're drafting opinions, it really is a complex process between the judges and the law clerks in how those opinions are written and edited. So an appeal is assigned initially for a single law clerk to review the filings. And then after oral argument, if you have oral argument, to begin the process of drafting the opinion on behalf of the judge who will be authoring it. So it starts off with just one law clerk. And that one law clerk, after doing an initial draft of an opinion, will do a self-edit. So edit his or her own work. After the self-edit, the law clerk shares that draft with the other clerks who all work for the same judge. So at that stage, you have 4 or 5 law clerks who are editing and reviewing an opinion before the judge even sees the draft. After the law clerks review the opinion, then that draft goes to the first judge, who will be the author of the opinion. That judge does editing and refining of the document. And when that judge is satisfied with it, then the opinion is shared with the other 2 judges on the panel and all of their clerks to review before the opinion is finalized and actually filed with the public. So 15 people on average review and edit each appellate decision. So that's a very thorough editing process, and that's how you avoid errors and limit errors. So with the courts engaging in such rigorous editing, that informs their expectations for us as lawyers and what we're doing before we file motions and briefs with the court. So with the court and how they're approaching our work, editing enhances our persuasiveness and credibility. You have to keep your audience in mind. And our audience of judges and law clerks, they are editing. They value editing. So for us as lawyers, we need to keep in mind that a careful and well-edited brief conveys that our analysis is reliable or that they can trust what we're saying. Conversely, legal editing that's replete with errors, inconsistencies, inaccurate citations will trigger the court's skepticism. They're less likely to trust our arguments. They're less likely to rely on our assurances if our documents that we're filing in court aren't carefully edited. So editing is how we secure a positive, first impression of our arguments and our legal work. I also want to highlight for you that editing is often required. There are times when it's just not optional to edit or not. So I'm sure most of us are familiar now with the issues that have come up with lawyers using AI technologies and in particular generative AI tools. So the key point when it comes to this is you must review and edit when you're using AI tools. So generative AI is a useful technology for the legal profession. It's an evolving technology in the legal profession, and more generally, it's something that lawyers should be aware of and stay on top of in terms of our learning. But one thing we should note is that generative AI so far has been proven to produce some unreliable results. And that includes, specifically for lawyers, hallucinated citations. So these are citations that just aren't real, or if it does take you to a real case, then what's being referenced isn't actually what's in the case. So in response to this issue, the American Bar Association has issued a formal opinion 512, which says a lawyer's reliance on or submission of a generative AI tool's output without an appropriate degree of independent verification or review of the output could violate the duty to provide competent representation. So the key point for us, anytime that we're using an AI tool or a generative AI tool to produce our work product, we need to review it, edit it, and confirm its accuracy before we submit it to a court. You also need to review and edit the work of legal support professionals. Many of us in our firms, we work with paralegals and legal assistants and investigators. And the ABA has produced guidance on the utilization of paralegal services. So we're permitted to delegate tasks that otherwise an attorney would perform to paralegal professionals. However, lawyers have an obligation to review the completed project to ensure that the work product is appropriate before we file or submit it on behalf of our clients. Another benefit that I would like to uplift with respect to editing is that it mitigates perfectionism. So perfectionism is a problem in many professions. In the legal profession in particular, perfectionism can lead to burnout, can lead to unhappiness and dissatisfaction in the legal profession. A perfectionist mindset contributes to attorneys and legal professionals leaving the profession because they can't find happiness and satisfaction in it. So that's something that we should always keep in mind. So having editing practices and consistency around editing in place will help us shift mentally from a perfection standard, which is not attainable, to an excellent standard. So I would offer to you all that recognizing that we are not perfect is key to attorney well-being. None of us is perfect. We may have moments of the sublime, moments where we achieve perfection, but being honest with ourselves, we have to know that we're not going to be consistently perfect in all of our work and all of our interactions. But what we can consistently achieve is excellence. Excellence is consistently attainable while perfection is not. So by adopting a consistent editing process to detect and correct errors, we can overcome perfectionism while consistently delivering an excellent work product for our clients. And that's what we should really strive for. So now we're going to talk about some preparation before editing. What do we need to do before we edit to set ourselves up for success in the editing process? So the first thing I will offer to you is set aside time for editing. Like any important work, like any meaningful work, editing will take time. And the biggest barrier to successful editing is just not allocating time for it. Um, so I recommend that when you receive a deadline for something that you need to submit or file, be proactive in scheduling time that you're going to write and scheduling time that you're going to edit. Um, what I see so often, and I see cause a lot of stress for attorneys and legal professionals, is procrastinating in the writing and editing process. And so many of us are at the last minute when something is due, still trying to write it, maybe leaving 15 minutes to look at it for a second before we go ahead and file it. And that's not the best practice for successful editing. And that's not the best practice for a happy work life. So I will offer to you a sample 14-day schedule that you might want to try out for how you would organize and plan your writing and editing process. So if you had a deadline of 14 days out that you needed to submit a motion or brief or reply or response, for the first 2 days, you could do your legal research. Your legal research is the foundation of your writing and what you're going to submit to the court. On the third day, I would prepare an outline. I strongly recommend an outline for the writer and for people who are editing after, because it gives you a roadmap of what your argument is. And we're going to talk a little bit more about outlining. Days 4 to 11, that can be the process of just actually writing what you're planning to submit. Day 12 is having a set time for self-editing, where you, as the writer, you're reviewing your own work product, you're making changes before you hand it off to an additional reviewer on day 13. And then lastly, day 14, that's your filing day. It should be an easy filing day. That's the best recommendation that I can make to anybody when it comes to writing is let filing day be an easy day. So often filing day is the worst day of the writing process because we know we're behind. We know we haven't dedicated time to do the editing that we should. And the clock is just ticking away and it's something that's due and it's weighing on us. As much as we can, I recommend filing day to be an easy day where you just have finishing touches and you go ahead and file it. Okay. Specifically about outlining, how do we create our outline? So, an outline is a numbered or bulleted list of topics and main ideas that you'll discuss in your writing. There are different ways to do it, and it can be simple or complex. But I think it's important to at least have a guide before you start writing of where you're planning to go. Otherwise, you might tend to adopt a kind of stream of consciousness style where you're veering from issue to issue and it's not really clear why you started with this and how do we get to the next thing. Having an outline will really help you in preparing to structure your argument so it naturally flows from one topic to the next topic. Um, Having an outline also improves the flow of legal writing because it allows editors to see the structure that you're intending to implement. And then editors can also make structural recommendations when they have an outline to see where you're trying to go. So if an editor is looking at your outline and says, I see you have this issue down at the bottom, but I think it's actually the strongest issue that you have in your brief. So for primacy reasons, I would recommend moving that issue up to the front, putting a weaker issue in the middle, and closing out with the next strongest issue before concluding. An outline is essential. It's really necessary when you're working on group writing projects. I worked on group writing projects before where we did not have an outline. And what tends to happen is multiple people end up writing about the same thing. And you might have situations where you're over your word limit because everybody was kind of covering some of the same topics. And now you need to cut back. But what do you cut? And, it can get really complicated. When you're working on group writing projects, I think it's really important to have a shared outline and be clear on who is covering which areas before you begin writing. And I want to share a little bit about organizing your research. Um, a lot of us in these days are using electronic databases for our research, whether it's Justia, Westlaw, Nexus. Um, And I recommend compiling that research, like pulling it out into a folder that you can go back to. And the reason for that is your folder of research can be a resource for your editors when they're reviewing the document. Like, oh, I want to go to that case. I'll just pull it up in the folder that's been provided to me that has all the cases. But it can also be a resource for you as a writing attorney as you prepare for future events in the case, whether that's oral argument or trial. You already have compiled and organized all of the research that you relied on along the way. And in making the best use of that research, I recommend the highlight and annotate method for organizing your research. And so what that involves is you're searching for cases that you think are on point for your argument. You've compiled all those cases into a folder. And then as you start to go through each case, highlight the key parts of the case, the opinion that you might use in your argument. So after you've highlighted throughout the key parts that you might rely on, then going to the top of the first page of the case, and then annotating with the key points from the case. For instance, if the case supports your argument on claim one, then that's something you will highlight at the top. And then secondarily to that, pulling out key quotes that you think you might want to use in your argument. That way, as you're writing, you're pulling up your cases and you can see at the top of the first page why this case is useful for you, and then key points that you might want to pull out and incorporate into your document. And also with research, good research leads to further research. So having your research compiled and organized in this way will make it easier for you to follow leads from one case to another case, or a case to a secondary source that can be useful for you. All right, now we're going to talk about some self-editing techniques. So this is techniques for reviewing our own work successfully. So self-editing is essential for strong writing. I recommend a self-edited for all legal writing of any significance. So this includes all filings, contracts, agreements, any other legal documents. I recommend also self-editing our communications with clients, um, emails and correspondence with co-counsel, opposing counsel, witnesses, government agencies, and the courts, and also any internal team communications or discussions that are delivering constructive feedback. So the first step in a self-edit is to step away. Take a break from it. Because what tends to happen when you're writing something, whether it's a long document or it's an email delivering criticism, is you don't always see potential errors, because just after you're writing it, is kind of invisible to you. You're seeing what you intended to write or intended to say or convey, but you're not necessarily seeing freshly what's actually on the page or on the screen. So I recommend before self-editing taking some sort of a break or working on something else. So it might be that you finish writing on one day, you take a break, and you come back and start your self edit the next day. Or if you finish writing in the middle of one day, go on your lunch break, come back and begin your self edit after that. Or you can just shift to another task and then come back to the original document you were writing. And that will help you have fresh eyes when you look at the material. And it definitely increases our ability to detect error or detect places where we might approach or communicate differently to reflect our intentions. So these are some practical self-editing tips that I think can be useful for you in incorporating into your writing and editing process. The first is check that all citations are accurate. That means that they're directing you or taking you to the correct authority and formatted correctly. In terms of the citation formatting, the Blue Book is the principal authority that we rely on, but also courts might have guidance on citation rules. Refer to your local rules in addition, but the Blue Book is the guiding authority for legal citations. And in confirming that the citation is taking you to the correct document, you can search the citations in Justia or Westlaw or Lexis to make sure that it's actually taking you to the correct document. And that's important from the court's perspective, because when they're going through your motions and your brief, they're actually going to those citations and pulling up those documents. So if you have an incorrect citation, it's not taking you to the correct case, then that just creates more hassle for the courts. And again, that kind of erodes the trust that they'll have in you as counsel if there are mistakes in the citations. Also, with the hallucinations produced by generative AI tools. If you have multiple citations in your document that are incorrect or taking you to the wrong place or the case doesn't exist, then that will raise those concerns for the court as well. In self-editing, Control F is your friend. Control F is a feature that works on most word processing tools or applications, and it allows you to search for particular words or passages or signals or punctuation marks within a document. And that can really streamline your editing process. So I use Control F to search for case names. To search for shortened case names. Like if the case was Williams versus Alabama, but I wanted to make sure throughout the document that Williams is italicized and spelled correctly, then I could do a Control F for WILL, and it'll pull up all of those examples, and I can make sure that that the citation is italicized and correct. I also recommend searching for signals and portions of the citation, like V period for verses, id period, and C. And this will help you for all those usages to find the reference and make sure that it's italicized appropriately and make sure that it's formatted correctly. Also, I use Control F to search for all quotation marks and apostrophes in the document. And this is to make sure that all of our quotation marks and apostrophes are curly. An interesting kind of feature with Microsoft Word and some other word processing programs is if you're copying and pasting within a document, your quotation marks and apostrophes may show up straight, depending on the font that you're using. Whereas if you're writing yourself, then your quotation marks and apostrophes would naturally be curly. So if within the same document, the courts and the law clerks are seeing some quotation marks that are straight up and down, some quotation marks that are curly, then that's indicating portions of the document that have been lifted from somewhere else versus portions of the document that you wrote yourself. And that's just an inconsistency, and it's something that stands out to the courts and to clerks. So to avoid that and to have a seamless brief, I encourage searching for those quotation marks and apostrophes and making sure that they're curly. Also ensure that all citation sentences have closing punctuation. Okay, I have a little bit more on punctuation that I want to cover. So, particularly with parenthetical citations, punctuation is a common error. The rule is that if the parenthetical citation contains a complete sentence within the parenthetical, then a closing punctuation is needed within the parenthetical. However, if the parenthetical does not contain a complete sentence, for example, if it begins with holding, noting, or some other gerund, then there should not be a closing punctuation or period within the parenthetical. Okay. Also, during your self-editing, I recommend that you check spelling and grammatical correctness, especially subject-verb agreement throughout. With complex legal writing, it can sometimes be tricky to determine whether the subject is singular or plural, especially when you're talking about groups sometimes, or states or groups of states, and it's not clear whether you're talking about individual entity or multiple entities. But an important thing to keep in mind with that is being consistent throughout. So when you have multiple writers working on a project and one writer is treating a group as a unit. And so it's treating them as a singular group, whereas another writer is treating it as a plural, then you could have inconsistency in your writing. So that's why I recommend in your self-editing, going through and making sure you're consistent in your subject verb agreement throughout. Also check that possessive apostrophes are placed correctly when referring to more than one person or thing. So for example, if you're talking about more than one intern, then it would be the intern's orientation with the apostrophe following the S versus apostrophe before the S, which is referring to just one intern. This is an error that I see a lot at number 6. Check that quotations of 50 or more words are formatted as block quotes. And properly formatting as a block quote means that it's single space. The quote is single space and indented on both sides. So something that I see quite a bit is maybe single space in the block quote, but only indenting on one side. But the block quote should actually be set apart on both sides. And next, consider the tone of your writing and confirm that the tone reflects your intent. As human beings, we communicate beyond just verbiage. So it's not just the words that we say that are communicating, it's what we may not say. For instance, if you're sending a communication to a colleague where you're delivering some constructive feedback, if you're not acknowledging the positive contributions of the person, but you're only acknowledging what you're concerned with, then that's potentially a mission that's communicating something to that person or that person's understanding. If you're writing an email to colleagues, but you don't include a greeting with them, but in other communications, you're including like, hi, how are you? Then that's potentially communicating something to them without you even actively saying anything or addressing anything. So when we're doing our self-edit, we also want to review for tone. In terms of the courts, the tone that they're expecting at all times is a civil tone. So, as upset as we may be with situations that are going on in the case, circumstances that are informing our litigation, we can't lose sight of maintaining a civil tone in our writing because that's what's expected of us. That's what's required of us as counsel. And then also, I wanted to include some points about editing tables of authorities or TOAs. Um, so, first, with the table of authorities, the most important part is confirming that the page numbers indicated in the table of authorities are accurate. So, the table of authorities is used by law clerks um, when they're reviewing briefs and motions, and they start the writing process of writing orders and opinions. If they want to go back to your brief and go find a particular case, then they go to the table of authorities, they look for the name of that case, and then they find the page numbers. But if you actually haven't confirmed that the authorities are actually cited on those pages, then it creates trouble for the law clerks and the judges in their writing process if they can't rely on your table to be accurate in showing where the cases are. Also, with tables of authorities, a common error that I see is just copying over the citation that's within the body text into the table of authorities and including information in the table of authorities that's not needed. So, in the table of authorities, we should remove pin sites. So that's directing you to a particular page within the authority. Remove all signals and remove all explanatory parentheticals because those aren't necessary for the table of authorities. The table of authorities is just a list of the authorities themselves. So that's the whole document. If it's a case that's in the table, then that's the whole case. If it's a law review article, then that's the whole article. The table of authorities shouldn't identify particular pages or portions or have explanations. It should just refer you to that document. And it's supposed to be a simple reference for the reader, which, our audience is often the courts and clerks for the reader to get to the full authority. I also wanted to share a little bit about PASM. So, when an authority is cited 5 or more times within a document, you may use PASM, which comes from the Latin word passus, meaning scattered, instead of listing all the page numbers where the authority appears within your document. However, there's an important note on that. The United States Supreme Court rules have been updated in recent years to disallow the use of PASM before that court. So I encourage you, because the United States Supreme Court is a model for other courts across the country and across the world, to check the local rules for the court that you're filing in to see whether they have any rules around PASM or rules forbidding use of PASM, because that restriction on PASM may tend to spread to other courts. So the key takeaway when it comes to self-editing is, unless it is unavoidable, don't submit your first draft of any significant work product without self-editing. So next we're going to talk about guidance for additional review. So first I want to discuss the scope of any additional review. So in addition to your self-edit, further review by an editor is recommended for briefs, memoranda of law, complaints, petitions, dispositive motions, evidentiary motions, proposed findings of fact and conclusion of law, and other substantial case documents of 5 or more pages. Additional review should address not only the grammatical and typographical errors that we kind of discussed before, but also the structure, organization, and overall persuasiveness of the document. So, first, when it comes to additional review, the first question is who should edit? And I recommend to you that an ideal editor is someone who possesses strong writing skills, demonstrates attention to detail, and is interested in providing support through editing. So there are lots of people within a firm or within your community who can meet that standard and expectation. Within a firm, other members of your case team or supervisors, supervising attorneys may serve as editors. But solo practitioners and small firms, sometimes it can be difficult to identify who would be an appropriate editor for my legal writing. So if you're a solo practitioner, you might consider colleagues in the legal profession as prospective editors. For my firm and other firms that I've worked with before, I've done a lot of work with interns and externs. And most law schools and have students who are looking to find mentors, who are looking to get some practical experience in the law, and are happy to volunteer or serve as an intern, extern, or just somebody to shadow you in your firm. And these law students can also provide editing support, and that's good, useful experience for them with law practice. Serving as an editor can also provide needed exposure to practice, not just for law students, but newer attorneys or younger attorneys just getting started as well. So, if you're an experienced solo practitioner, it could be a great idea to partner with a newer solo practitioner on editing projects, and that's helping the newer attorney get exposure to practice as well. And I have some tips for being a good editor of others' work. So the first tip for editing is to value the authorial voice of the person whose work you are editing. Editing is a difficult process for the person whose work is being edited because it requires you to be vulnerable. Your work product is something that you've poured yourself into. You've put your time into it. Um, and we're all mostly trying to deliver our best work when we work. And so as an editor, you have to have in mind that the person who's providing their work to me to review, that they cared about it, and I should have care as well in how I communicate with them about it, and also the respect that I show for them as a fellow attorney or legal professional and writer. Um, as an editor, you have to thoroughly review. It's very difficult for the writer to hand their work over to someone else and trust that that person is actually going to go through it, look for errors to help make the best written work product that you can, and to actually find out that the editor wasn't putting as much interest and effort into editing the document. That's not good. When you're editing, that's something that you should take seriously. Flag all errors and confusing passages for correction. This is something that I learned. Number 3 is something that I learned as a law clerk at the appellate level. When we're conveying just stylistic suggestions, it's not actually errors, but we have recommendations that might improve the writing or how the writing is received. I recommend using consider as a preface for those sorts of recommendations. And that's just letting the writer know that it's optional. that the way that they have it isn't incorrect, but this might improve how the writing is received. Something that I recommend, but I don't think is consistently done, but I do believe would improve the editing process for a lot of firms is to remember to compliment the writer on what works well and what resonates with you. The editing process is not only about errors, it can also be about acknowledging good work and reinforcing positive attributes of writing. So if there's a particular turn of phrase, the way that something is communicated that you think stands out and works really well, you want to reinforce that positively so that in future writing, the person can bring that skill set into their future writing because you've highlighted that that's an area where they're successful. And lastly, and maybe most importantly, timely return the edited document to the writer. What can really stymie the editing process and make people reluctant to participate in editing in the future is if editing just creates unnecessary delays and bottlenecks in the writing process. So the key takeaway on additional review that I want to leave with you is that additional review is recommended for all major filings. I encourage you to select editors who are careful, conscientious, and timely. And in the last section, we're going to just cover some technology tools for editing that might be useful for you, and at least give you some examples of tools that you might want to research to help you in your editing process. So Microsoft Word, for most of us, I think Microsoft Word and Microsoft Office are foundational for our editing process. For legal writing, Word has tools that can help you prepare your table of contents, your table of authorities, and there are resources available online to show you how to incorporate those parts of legal writing into your document using Word itself and the features within Word. Microsoft Office also has Copilot. That's the AI tool within Microsoft Office. With Copilot, you can give prompts. Copilot can help you make adjustments in how you're phrasing things. But also keep in mind with any AI tool, you need to independently review it and be satisfied that it's correct before you submit it to a court. Scrivener is another tool that can help with writing. It's not only for legal writing, but more generally, it can help with editing and phrasing. And it's a useful tool for that. It's similar to Grammarly, which is a popular tool as well to help with editing and revising. The Blue Book Online is something that I rely on for writing. A benefit of the Blue Book Online relative to the hard copy version is the Blue Book changes. It's revised, and all of the revisions are incorporated into the Blue Book Online. Whereas, you just have to buy the newest edition to have the newest changes. So the Blue Book Online is a subscription service, so that's something to consider. Next, we're going to talk about some options that can help with generating tables of authority. So, in addition to using your word processing system to generate your tables, there are also tools and applications that can help with that. Best Authority by Litera is one tool that can help with generated tables of authorities, and it may be simpler for you to use than doing it manually in Microsoft Word. And within Thompson and Reuters Westlaw, then you also have drafting assistant and co-counsel, which has AI features to help with tables and the legal writing process. Perfected is a proofreading software that can help with editing. Definely Proof is a proofreading software that can help, particularly around contracts. And the Justia legal dictionary. If you're like me and you still have the same copy of Black's Law Dictionary from when you were in law school, Justia legal dictionary is available to you, and we'll have more up to date definitions that reflect the changes in the law over time versus the Black's Law Dictionary that you might have purchased some time ago. With any editing technology, I encourage you to select tools with features that help ease the tension and the stress around writing and help make the drafting and editing process more expedient. Look for tools that integrate with technologies you already use. Like Best Authority, for instance, integrates with Microsoft Word. Um, don't let editing technologies get in the way of your review process. And remember, especially with any generative AI technologies, that we have to check behind the machines. And now it's time for Q&A, and I'll stop sharing here.
Wonderful. Thank you so much, Keisha, as always, for all of your insights. We really appreciate you being here with us today. All right, Keisha, it looks like our first question is, when you're balancing time constraints through editing, what criteria do you think can help determine whether a section needs to be completely reorganized or just like a lighter line edit? How do you kind of differentiate that?
Well, I think starting off, even before you write it or have the completed product with your outline, will kind of help you avoid situations where you need to completely rework it. I think we tend to get there when we didn't have an outline in the first place. Maybe we're reaching our word limit and now we know we need to move stuff around and take stuff out. And like that can be really stressful, especially when it's at the last minute. Um, I think relying on your team and your colleagues to kind of help you manage that is the best way to go about it. If you share your work with a colleague and they're like, oh no, this doesn't work at all, so then we will need to just completely change things around with limited time, then that's what you should do. If you share it with the reviewer and they say, yeah, I mean, I think it has good points, but it has points where I think we get lost. Let's go through together and kind of work through which portions we can excise and the rest we'll keep given the time constraints that we have. But I really recommend outlining for teamwork to help avoid some of those situations.
Thank you, Keisha. That's really helpful. Our next question is, in practice, how do you manage efficient drafting when different courts have some differences, whether it's stylistically or citation wise?
Yeah, that can be a challenge. There definitely are courts that have, they only want you to use this certain font, and where you're kind of incorporating an argument from somewhere else and then, you're not paying attention, then that can be an easy ding. It's like you didn't use the magic font. I think the important thing when you're working with different courts, again with teamwork, empower your paralegals, the legal professionals that you're working with, to stay on top of things like local rules. Are there rules for certain fonts that we use? So you know that ahead of time and not at the end of the writing process where it's like, oops, I didn't know we needed to use this particular font. Now that throws off my page limit. Like know that from the beginning and empower the support professionals that you're working with to keep up with those details.
Awesome. Thank you. This next question is, what role does editing play in managing some confirmation bias when you're reviewing your own arguments?
Oh, I think it plays a big role. I think it plays a big role. A key aspect of being an attorney is to be critical. and not in a negative sense. It means we're approaching decision points and questions with a critical eye, and we're not just taking everything for granted. And that has to be with our own work as well. And that's part of the reason for stepping away before you self edit, because that confirmation bias is already embedded in our writing. As we're writing, what we're perceiving is what we're intending to say and not necessarily what we said. So, knowing that about ourselves, taking a step back, and then returning to the writing with fresh eyes, that's also acknowledging maybe I made a mistake that I didn't see before. So, I'm going to look really critically at my own work to make sure it's correct before I share it with someone else.
Thank you, Keisha. So you also mentioned teamwork as being a great way to kind of work through the editing process. And this person asks, in collaborative teams, what safeguards can be built into the editing process so that you're not diluting strong arguments or over editing when you have more than one editorial voice?
You're not diluting strong arguments. Okay, I think one part that needs to be included in the editing process, and maybe I didn't discuss this specifically, is that editing should be collaborative, which is if you're the person whose work is being edited, you should understand, and the person who's editing your work should understand that if you have questions or if you feel strongly about an argument, that y'all can have a discussion about it. And even if that person is a supervisor, even if that person runs the office, part of the editing process and just the honesty and trust that should be built into it is knowing that we can have a conversation where there is disagreement. It doesn't mean that the person being edited will necessarily have the final say. But you should be able to raise a concern if you feel like the editing didn't take into account something that was important. And having those conversations around editing, it helps develop not only the writer, but also the editor.
Thank you, Keisha. It's a great tip. This next question is about some of those technologies so that can be utilized for editing. So this person asks, which editing technologies do you see as working really well for legal practice today? Or where do you think that lawyers should be cautious about over-reliance?
I would say cautious about over reliance. General publicly available AI tools, generative AI tools like ChatGPT. That's a place to be particularly cautious when it comes to legal writing. Is not a legal tool. It can help you with your legal writing, but you need to check behind it. That's not primarily what it's for. And that's where you're more often going to see the hallucinations. There are generative AI tools that are being built within specifically legal technologies. So specifically within a legal research database, there might be an AI tool that is pulling just from within that database. Is geared towards law practice. And so it's more likely to be reliable from a legal perspective, but you should still check before you file anything where you're using a generative AI technology. But some are just more geared towards the legal profession than others.
Awesome. Thank you, Keisha. We have time for a couple more questions. So this next one is, how do editing practices differ when you're preparing persuasive briefs versus transactional documents? What do you feel like are the differences there?
Um, I think you have to be careful about editing with both. I'll say persuasive briefs, you know immediately because we're in an adversarial process that your arguments are going to be challenged. Whereas with transactional work, whether it's a contract, lease, or deed, potential legal conflicts coming out of that might be years down the road. So I think it's very important maybe to be even more careful in your transactional writing that you're saying what you actually intend to say, because it might be some future date on down the line that someone else is going to be dealing with the ramifications of your transactional writing. And whether it's litigation or transactional work, our most important duty is to protect the interests of our clients. So you want to bring scrutiny and a critical eye to your writing, whether it's litigation where you'll immediately be challenged, or whether it's transactional work where challenges may occur down the line.
Thank you, Keisha. And then our last question for today is, do you have any tips or advice to avoid over self-editing? When do you know when enough is enough?
Yes, I do. I think, and that's where the perfectionism comes in. So, like, really shifting that mindset from a perfection standard to an excellent standard. Um, from a perfection standard, you're anxious, you can't be satisfied. Um, I think in the back of our minds, we know we're not perfect. So there's always something that we could do differently. And if you can't accept less than perfect, then the editing process is going to be difficult for you. Shifting to an excellent standard is knowing I did my best within a reasonable time to correct any errors that I could identify. If it was a significant document, I've also set up processes by which additional reviewers will look at it and approve and recommend changes. And with that, we as a group can be satisfied that this is an excellent product and the best product that we could produce, and just accept it. Sometimes I go back and I'm like, oh, I would have had a comma there. I do still do things, but I know that I had a process that worked, that can deliver excellent results, even if they're imperfect.
Thank you so much, Keisha. We really appreciate that insight. And thank you for answering all of our audience questions. And to all of our audience members who submitted questions, thank you as always for your participation. We really appreciate it. We want to thank you all so much for joining us for another Justia webinar. I wanted to remind you all, as I did at the top of the presentation, of the services available to you through our website platform, Justia Elevate. It's our innovative, feature-packed website solution that's designed specifically for law firms. It has tools like our Justia AI Writer to help you produce content, the AI-powered Justia Chat to help you boost your leads, and the new FAQs for AI to help you show up in those coveted AI results. If you'd like to learn about your pricing and what Elevate might be able to do for your firm, you can go to elevate.justia.com/price. Thank you all so much for joining, and thank you, Keisha, as always, for your presence and presentation. Have a wonderful rest of your day. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.